Hi, this is Nilgün Zahour from SM JUROR, and today we're going to be talking about the juror misconduct issues in the case of Fairbanks versus State, which is out of Indiana. Here we're going to talk about suspected juror misconduct and the presumption of prejudice, the shifting of the burden of proof to rebut that presumption, invited error, and a juror's cell phone use to possibly research police investigations and credibility on YouTube. First, I want to talk about the presumption of prejudice when seeking a mistrial based on suspected jury taint. A presumption of prejudice exists if two requirements are shown by a preponderance of the evidence. First, that there was extrajudicial contact or communications between jurors and unauthorized persons, and second, the contact or communications pertain to a matter that was before the jury. If those two requirements are met by a preponderance of the evidence, the burden then shifts to the other side, or in this case the state, to rebut this presumption of prejudice by showing that any contact or communications was harmless. If the state does not rebut the presumption, the trial court must grant a new trial. Now, in this case, it was a murder trial involving the disposal of an infant in a dumpster. The defendant was found not guilty of murder, but guilty of neglect. He appealed his verdict on several grounds, including juror misconduct. Here, defense counsel reported to the trial court that his law clerk observed a juror in the hallway researching something on her cell phone about police investigations or credibility, and the law clerk thought it might possibly be a how-to video on YouTube. Defense counsel reported that it did not appear that the juror was researching the defendant or the trial, and the prosecutor also stated that he did see the juror in the hallway, which was unusual. The trial court asked defense counsel twice whether he wanted the court to question the juror, and defense counsel was reluctant to do so because he was worried about the ramifications on the defendant if the juror was questioned but then remained on the jury. So he indicated he wanted nothing done, and so nothing was done at that time. On appeal, he said he was denied a fair trial due to juror misconduct. The Indiana Court of Appeals affirmed the conviction on the following grounds. First, at no time did the defendant ask for a mistrial based on suspected juror misconduct. And since the defendant did not do so, the presumption of prejudice due to suspected juror misconduct did not exist. Second, defense counsel was asked by the trial court if he wanted the trial court to question the juror about the cell phone use in the hallway, and defense counsel declined to do so. As such, since the defendant invited the error into the trial, he cannot now benefit from it. And third, in essence, the defendant got the precise remedy that he requested when the suspected juror misconduct was reported, and that was to do nothing. So he can't appeal from his own chosen remedy. This concludes our analysis of the juror misconduct issues in this case. For more information about other juror misconduct issues, our CLE courses, and other updates, please click on our website. And remember, don't let juror misconduct taint your next verdict. I'm Nilgün Zahour from SM JUROR. Thanks for watching, and see you next time.